One of the arguments offered in defense of our divorce laws is that prior to no fault, married women were not granted an equitable distribution of marital property. For instance, in Illinois, the rule was that property typically followed the party in whose name it was titled. So if the title to the marital home was in the husband's name, the husband would typically take that property in the event of a dissolution. And since men typically had more property titled in their name, many assumed that men were getting an unequal distribution of the marital property. This, once again, however, is not a correct understanding, because titling of the property notwithstanding, there was in effect a principle that a husband had to maintain his wife in financial circumstances that were similar to what she had enjoyed during the course of the marriage. And this principle is explained very clearly in a 1919 case from Kentucky known as Kelly versus Kelly. Even though this was a Kentucky case, this principle was followed in almost every common law jurisdiction. The case reads as follows. The principle applying, whether the granting of permanent alimony be considered as damages for breach of the marriage covenant or the exercise of a sound judicial discretion in providing for the wife an allowance out of the husband's estate, is that the alimony awarded should be so apportioned as to secure to the wife the same social standing, comforts, and luxuries of life as she would have had but for the enforced separation. Now, I've seen some scholars argue about whether or not women actually were usually awarded this type of permanent alimony, but it's not really relevant because the principle ensured that there was going to be at least some sort of equitable distribution of the property. This mentality that marriage oppressed women and that they were being cheated in the event of a dissolution, this mentality is what led to no-fault divorce. By way of example, one of the first organizations to advocate for no-fault divorce was the National Association of Women Lawyers. In 1969, they got their wish when California became the first U.S. state to adopt no-fault divorce. Many states followed suit thereafter, and the rest is history, of course. In future videos, I'm going to talk about how this played out, and spoiler alert, it did not play out well.